Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. About 7 hours of argument time has been requested, so please be merciful. We've read your papers, and we're familiar with the issues that underlie your appeal. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise, and please let me know how much time, who you represent, and how much time you are requesting. People versus Henry Gonzalez, submitted. Dean versus State of New York.
I represent the State of New York, and I would request 5 minutes and 1 for rebuttal.
4 and 1 and 4. J. Children is submitted. Ebrahim versus Twin Development. 5 and 2 and 5. Schwarzer v. Young Men's Christian Association. 5 and 2 and 5. Wilson v. Tillman.
Respondent requesting 3.
We'll do 4 and 1 and 3. People v. Stephen Delone.
Respondent requests 4, Your Honor.
5 and 2 and 4. Museum Building versus Shriber.
Appellant 5 and 2.
5 and 2 and 5. Uniformed Firefighters versus City of New York.
On behalf of the appellant, Uniform Firefighters, I request 5 and 3.
Okay, we'll do 5 and 2 and 4 and 4. People versus Randy Garcia. Submitted. State of New York versus Griffin is already submitted. Bone versus Tukolsky. Submitted. Valley National v. 252 West 31st.
For the appellant, 4 and 1.
Respondent, 3 minutes, Your Honor.
4 and 1 and 3. AB Commercial v. Holtzman.
For the respondent, Your Honor,
5 and 1 and 5. Kato versus Four State Commercial. No one else is here? Do you want to rest on your papers? Do you want to hear? You want? Two it is. People versus David Akokpe.
Appellant requests 5 and 2. Respondent requests 4.
5 and 2 and 4. Carlotos versus Newsmax Media.
The appellant, 5 and 2.
5 and 2 and 5. Thank you. First case up is Dean versus State of New York. Please.
May it please the court, Doug Wagner on behalf of the State of New York. This is a simple case. The only question before the panel is whether or not the claimant put the state on notice of the need to defend against the allegations involving C.O.
Right.
Fernandez.
Of course, the original complaint did refer to 4 COs by name, but also to others, quote unquote.
It's true, Your Honor, that there was a definition of alleged offenders. That definition seems to pertain only to those who were described herein. In the original claim, there were only 4 officers. None of them were C.O. Fernandez. And insofar as it did refer to any unnamed officers, there was no allegations in the claim of particular facts that went to these
But
unknown.
counsel, the amended complaint does concern the same time period. You'd concede that.
I conceded that it's the same time period, but I do not concede that that is determinative or even relevant. Consider the hypothetical in which I sue someone for an assault that happened on January 1st, 2025. 10 years go by in protracted litigation. I can't sue that same person for an assault that happened on January 2nd, 2025, just because those two fact patterns happened close in time.
Same, oh, please.
Were there any proposed new causes of action?
There were no proposed new causes of action, but that too is not relevant. The question is whether or not the facts laid out in the original claim were either amplified or, if the facts in the original claim are amplified, then that amendment is okay. But if in the amended claim there are wholly new facts which you cannot trace back to the original claim, then that amendment is not okay, and that's what we have in this case.
Are you arguing?
New facts, so I'm not seeing, how you're even prejudiced here.
Your Honor, the new facts pertain to C.O. Fernandez and his assault. So it says C.O. Fernandez assaulted the claimant allegedly in the day room. The day room was never mentioned in the original claim.
Amplifying the pleadings.
I strongly disagree, Your Honor, because an amplification of the pleadings would be C.O. Fernandez assaulted me on such and such a day and such a time, and then amplifying that would be he also said X, Y, and Z, or the state should have known of his propensity to sexually abuse because of these other facts. But having a new individual who was simply completely not named in the original claim means that it doesn't relate back when that individual is named in the amended claim.
But are you arguing surprise and prejudice?
We are not arguing surprise or prejudice, but we don't need to because as the appellate division has held consistently for a long time, amendments need to show surprise or prejudice if they are not patently devoid of merit, but a time-barred claim is patently devoid of merit per se. And so,
But, I mean, you're saying that the claim is time barred, but this particular claim is here underneath a specific statute, the Adult Survivors Act, right? So we would have to apply that to every other claim. So I don't necessarily know if your argument is that distinguishable just based upon it being time barred, because we're dealing with time barred claims, but there's a reason why they're here now.
Your Honor, the issue is that the ASA window closed and this amendment fell after the window had closed. So if these claims were all brought when the ASA window was still open, we wouldn't be here today. But under the logic posited in Your Honor's question, then the window would be open forever because amended claims could be brought forever on the theory that the first claim was brought during the window. And that's not how the court should read the ASA window. Finally, just for the same reasons but independently, the Court of Claims lacked jurisdiction over these belated allegations. As this court well knows, to plead under 11B of the Court of Claims Act, a claimant must show the time when, the place where, and the nature of the claim. Here, because C.O. Fernandez wasn't mentioned in the original claim, of course the Court of Claims did not have jurisdiction over
Also,
claims.
but the allegations here are not against C.O. Fernandez. They're against the state of New York.
That's certainly true, Your Honor. But as the cases that we've cited show, even when there's an employer involved, may I finish this response? Your
Please.
Honor? When different employees undertake conduct that could be liable, attributable to the employer, that conduct still needs to be in the complaint. It's not a free license to add other employees at different times. Thank you.
Thank you, counsel. You have time in rebuttal.
May it please the court, Jay Breakstone for the claimant. This case is absolutely the mirror image of something we heard argued, I think 2 weeks ago in the Court of Appeals. In Wright, there was a situation where the state made the argument that it didn't have enough information. The claim was not specific enough, and that was the violation. Here we have a situation in which every single corner of this claim is pled in the complaint. Every single corner.
You heard your opponent make the point that the others referred to in the initial complaint were not accused of doing anything specific. No actions were tied to the others. And so does that distinguish this case?
Yeah, well, this is solely a claim against the state. And the others that are mentioned, at that point, the claimant mentioned the ones that investigation showed. And then the amendment and the relation back is clear, because the guilty party, to use that term, is the state. It's not the correction officers. There is only one person on the other side of this caption, one individual, and that's the state. That has never changed. And if we flip this around and we turned around and said, well, could we bring this up? Could we bring in Officer Fernandez's conduct at some other point in time in this proceeding, or anybody else's conduct, or discovery discovers the additional names of officers? Remember, this is a situation totally controlled by the state. The state controls this situation completely. This place, these two correctional facilities were like a snake pit, and the state controlled that snake pit. Knew who was going in, who was going out, who was supposed to be there, who wasn't supposed to be there, what time they were there, when the victim was there. They were in a custodial situation. So to turn around and argue that we could bring this in at a later date, and then of course that later date argue, why don't we bring it in at the earlier date, seems to me to make little sense. The fact is, this is merely an amplification of the pleadings, in the truest sense of the word, an amplification of the pleadings. And rather than being chastised for doing so, the state should be happy that we did, because obviously the state did not know about Officer Fernandez, or maybe the state did, but we don't know, because that's not in this case at this point. But it would be in the point later on if the state took the position that, well, why did you bring it up now? So here, the claimant is being faulted for bringing it up at this point in time. It is solely an amplification of the pleadings, and there's no other thing, that no manner in which it can be explained. And so I don't see the problem, to tell you the truth. And I think that the problem the state has is far deeper in this case than adding another officer's name to those of the 3 or 4 who are already mentioned in the complaint. Thank you.
Thank you, Counsel.
Thank you. It is not a mere amplification of the pleadings, and how the panel can understand that is, consider a claim that was similar to this, but instead of having any of the 4 officers that were named in the original claim, the claim only contained the allegations that there was a systemic problem of sexual abuse at correctional facilities in the 90s. And then at time 2, when the amended claim came in, the claimant could, under the theory proffered here, add 30 assaults by 30 different correction officers. That's not how relation back works, and it doesn't matter that it's not a new legal theory or not a new defendant. Thank you, Your Honors.
Thank you. Thank you both. Ebrahim versus Twin Development.
Thank you.
Good afternoon, Your Honors.
Hold on a second, Counsel. Give me a moment.
I'm William Kerrigan, and I represent
Give me a minute, Counsel. I'm just getting the clock set up. Hold on. Thank you. I'm setting up the clock. Just give me a sec.
Yes, sir.
Please, you can go ahead now.
All right. I am William Kerrigan, and I'm pleased to be here representing the appellant. If I speak too loud, please let me know. I'm kind of wired for sound. And the first thing I'd like to address is the error that was introduced into the record concerning the very, very critical language of the contract, which was the lease. It was represented to the court by respondent, and I don't claim that this was done deliberately.
Of course, they say it was immaterial. Your opponent says that the misquote, which is correct about, is immaterial to their argument.
I guess I'm getting too old for this. Would you repeat that for me, sir?
Well, their response to what you said about their misquote is that the misquote was immaterial, doesn't matter.
Well, since there are 2 exceptions to the liability of an owner out of possession, and the first one is if the owner takes on a contractual responsibility, I don't know how that's irrelevant. And it was the centerpiece of the court below in Judge Lattin's decision. So the difference between owner has an obligation to enter and repair, and the owner does not have an obligation may seem irrelevant and unimportant to the respondent, but but not to me.
Let me ask you about the other part. Was the alteration a structural alteration?
I'm sorry again, sir.
Was the alteration, removing the rail, a structural alteration?
Well, it was not, and that comes to the second, and I think the linchpin issue for this court, and that is whether the creation of the stairway and the trapdoor, and let me get this language right, was a significant structural defect which was contrary to a particular statute or code. This is not new territory for this court. This court in Yu Yang and
Counsel,
Suti.
no, you do a good job citing those cases, but none of them seem to involve the situation we have here, where there's only 26 inches from the exit from the bathroom to this fairly perilous drop down the open hatchway. So,
Your Honor,
it seems like the facts might distinguish this case from Keelong, which
Judge,
I'm probably
I think not. In my brief, I cited to my client's testimony, which is unrebutted. I cited to pages 290 and 292 record. I just want to enlarge that to 286 to 292 and give you the factual presentation. This set of stairs led from the first floor down to the basement. The basement was a storage area. It was solely under the control of JAB, J-A-A-B being the tenant. The walls were, my client described it as New York City bedrock, and there were no required exits. Now, I know there are no required exits because this building was built in
But that seems peripheral to me. It seems more important that just looking at the photograph, it would be so easy for someone looking at their watch or their phone as they exit the bathroom and just to go right down to the basement.
Well, that's a question of, did I interrupt you, Your Honor?
Please.
Yeah. That's a question of the proximity, and that's covered by this court in the Baez, B-A-E-Z decision. That's a case which I think has more appeal than this case. It was a customer with no knowledge whatsoever of the existence of the trapdoor, and this court dismissed as against the owner out of possession, and said basically that the trapdoor was not dangerous unless it was left open, and that's the rationale for Bing, for Baez, for Quinones, not Quinones, Yu Ying, and Maksudi.
Counsel, what do we make of the plaintiff's experts?
Sorry, Your Honor, may I approach without?
I'll speak into the mic. Is that a little bit better for you?
Thank you.
Okay. What do we make of the plaintiff's experts, or the fact, rather, that at one point this hatch, this trapdoor, was surrounded by a barrier, and then that barrier was removed? Does that change any of the facts as the cases that you're citing?
Sorry, I'm at a loss. I can't hear you.
At one point in time, the trapdoor was surrounded by a barrier, and then at some other point in time, that barrier was no longer there. Does that change the analysis under the cases that you've cited?
It does not. I think factually, when the property was rented and delivered to JAB, it was an enclosed staircase. Sometime after that, JAB removed the enclosure and installed the trapdoor. Now, my clients deny knowledge of that, but that could be a question of fact. Whether they knew about it or not, the question is whether it was a significant structural defect. And this court has repeatedly said that a trapdoor is not a significant structural defect. I've cited numerous cases, and it becomes dangerous when it's left open.
Thank you, counsel. You have time on rebuttal.
Thank you, sir.
May it please the court, Your Honor, Brian Isaac, I represent the plaintiff respondent.
Mr. Isaac, what about Baez? That seems to be a very difficult case for you to get around.
The difference in Baez and the difference on the trapdoor cases, and you know from reading the briefs that I was actually involved in some of those, is that here, and your language is actually interesting, here the reconstruction was illegal. It was not done in conformity with building code requirements. And Your Honor, I can make this very simple for you. It's a big record. If you look at 149 of the record, that's what my client saw. Steps out of the bathroom, 26
That's
inches.
the photograph. It's a very, it is one of those photographs that is, tells 1,000 stories, yeah, or
Yeah, sure.
worth 100 words, yeah.
And if you then turn to the next page, because these are sequentially, 150 and 151, you see the original construction. The original construction had walls around it. And the expert says, and it's not disputed, that the building department plans didn't approve the recreation of this particular device so that it became a trapdoor with no visual clues at all. Now, if the cases that my adversary...
But how do we get from that to the out-of-possession landlord?
So I think the argument is straight out, Your Honor, just out of Guzman, right? The Guzman decision from the Court of Appeals, Guzman against Haven Plaza, specifically says, and I'm quoting, and this is important because my adversary also pointed out that his client never actually inspected and had no knowledge. This is a direct quote from Guzman. Although the owner had not inspected the premises and had no actual knowledge of the defect, the court held that its retention of the right to inspect was a sufficient basis to sustain liability, and that the owner should be charged with constructive notice of defects in all those parts of the building into which, by authority of the written lease, it may enter. And then 3 paragraphs down, the Court of Appeals says, again, not Brian Isaac, this is the Court of Appeals, although there is no evidence that Village East had actual notice of the claimed dangerous condition, its right to re-enter the premises is sufficient to charge it with constructive notice. And let me go even further. Everybody talks about Guzman as the structural defect case, but there's one other part of it that I'd like you to consider. The owner in that case said, I gave a triple net lease to Daich. I didn't do anything wrong. They had a right to do whatever they wanted. I want indemnity because I didn't do anything wrong. I'm not affirmatively negligent. And the Court of Appeals rejected that. And it said, and I'm quoting again, here the liability of Village East is not derivative. The award of damages does not depend solely on the negligent act or admission of another. On the contrary, Village East is held responsible for failure to perform a duty owed directly by it to plaintiff, a duty to remedy the defect, something it was permitted to do under the lease and obligated to do under the administrative code. So this case is right on. This is a structural defect. If you take a look at the code provisions, you can say what you want about them, but clearly the building code of 2008, 1012-1, requires that there be some type of barricade around here, and it just wasn't there in violation of the building code and in violation of the plans. One further thing, and I'll...
But we have approved hatches, including hatches in restaurants, in the interior of restaurants that did not appear to me, at least from my understanding of the cases, have a balustrade.
But you have a remember, I'm opposing summary judgment. So
Yeah,
the
yeah.
evidence gets looked at in the light most favorable to me. You have undisputed expert testimony that based on their inspection of the building code itself on microfiche, the reconstruction that was done was not approved by the building department. The prior building department plans obviously had walls. We have a direct code provision from the 2008 code that wouldn't be subjected to Maxudi analysis or a Gaston analysis. Unfortunately, another case I lost in this court, but we'll leave that alone. And the truth of the matter is the Maxudi case is fundamentally different, and I can tell you why. In Maxudi, I argued that the 1916 code, which did not have a definition of a required exit, was different because the 1968 and the 2008 code did. I thought it was a good argument. Clearly, you rejected it. But the difference was that in Maxudi, my argument was you would have to change the trapdoors in the city everywhere to change for risers and treads and handrails. That's not my claim here. Here, my claim is that they're the ones who improperly changed the design. So you don't have the same considerations. So based upon all those factors, let me suggest to you that the trial court got it right. If you have no questions, I'll let my adversary reply. Thanks for listening to me.
Thank you.
I take no issue with counsel's comments about control. There's no question that my client had a right of reentry. The question is, was the trapdoor a significant structural defect that was contrary to a particular code? And it was not. I ran out of time. May I address an issue raised by counsel having to do with whether or not my client was an owner out of possession? As with any landlord-tenant relationship, there was emails and telephone calls back and forth between 2011 and the beginning of 2014. Respondent lists these 1 through 16 as if there were a great many. They come down to 3. One of them was whether or not, it predated the lease agreement, whether or not exterior gates could be removed. There was another, the second was whether or not some pipes could be removed. And the third was the replacement of a roof. The roof happened to be a common roof over all 3 structures. And I want to just conclude by citing to the SAP case. SAP was a case involving a set of stairs, this department, and the claim was that the owner was not an owner out of possession. And I just want to quote what this court said. The first question is whether specifically with respect to the staircase, was there a transfer of possession and control? So I would respectfully submit, if I'm reading this correctly, that there was really no issue that the staircase was transferred to JAB. And the citations to the emails involving the roof, the gates, and so on fall very far short of what would be required to deprive my owner of the protection of being an owner out of possession. And unless you have questions, I thank you very much. I've enjoyed the argument.
Thank you, counsel. Thank you both. Schwarzer versus Young Men's Christian Association. Please.
May it please the court, Andrew Kaufman from Miranda Sloan on behalf of the defendant appellant, YMCA of Greater New York. The appeal takes issue with Justice Lattin's finding at the last page of his order that the YMCA, as the movement, failed to make a prima facie showing. The YMCA supported its motion for summary judgment with admissible evidence, not just from its deposition witness, but from the aquatics director, Mr. Patel, who the plaintiff called in her accident to later on the day of the accident, and the sworn affidavit of Ms. Mohar, known as Sandra, the lady who was responsible for cleaning
Ms.
the
Mohar had a particularly specific memory of that day.
based on the investigation that Mr. Patel inquired about. And not only did she investigate, not only did she retell what she did that day, which this court has held is admissible evidence of regular and routine cleaning with or without a written record of it. She also,
What's your best case for that proposition?
2 cases from this court. One is Phillip versus Young Men's Christian Association from 2014, and another case called Warner versus Continuum from 2012 from this court as well. Ms. Mohar also put in her affidavit that the plaintiff gave a totally different version of how her accident happened. The YMCA also supported its motion with the expert affidavit of its engineer, Mr. Patera, who identified the floor area, testified about his, he averred about his testing, and he said that this was an appropriate floor for the area. So at the outset, I think the YMCA clearly established that it made a prima facie showing of its entitlement to summary judgment with all of the admissible evidence that it submitted. And Ms. Mohar's affidavit was very specific if you look at pages 430 to 432 of the record. She made rounds in that locker room from the time she got there, hours before the plaintiff. She observed no water or slickness in the area. She observed no wet conditions. That was all in her affidavit. She even put in, she walked over the area many times that day and observed nothing. Mr. Patel, in his affidavit, he put in, he had no reports of anyone slipping in the women's locker room. Not only that day, but for years. So number one, we think the court erred in that vein. Then the court ruled that the YMCA failed to establish it had no constructive notice of the condition. Well, if there are no other accidents, and we gave evidence of regular and routine cleaning not only on that day, but days before, I contend that the YMCA established its entitlement to summary judgment. And the court never shifted the burden to the plaintiff, who clearly said, pages 99 and 138, she didn't know where the water came from. She speculated it came from people coming from the showers or using the sinks.
She did not walk through the area where she fell.
Well, that's very important. She was there for 74 minutes, 60 of which was spent in a swimming pool. She never walked through the area that morning. So there was no way she could rebut or establish, I should say, that the YMCA had constructive notice of this very specific wet condition on that day. And then
She didn't know where the water came from.
she had no idea. And that goes into my third point, that there's no evidence of a recurrent condition. There's no evidence of a leaking pipe or leaking sinks or anything like that. This is a transitory condition. And because the burden never shifted to the plaintiff in Justice Lattin's analysis of the facts and the law, he simply denied the YMCA's motion. And I contend that that was an error. And I want to just bring out one other point that I didn't really raise in the motion, but I want to raise it now. The plaintiff testified that when she got to the area—
Counsel, usually you're precluded from raising it in front of us if you didn't raise it in the motion.
It was raised in the motion, but it wasn't highlighted as
Please continue.
a specific argument point. She testified, she sees this puddle of water. She says it's 1.5 feet by 1 foot wide. She planted her feet in it, okay? But she doesn't move. She says, I'm about to turn to my left, and I fell. I'm not even sure that the wet condition is the proximate cause of her accident. Her stories collectively throughout this case are extremely dramatic. They don't rely on any proof, and the motion should have been granted.
Thank you, Counsel. You have time in rebuttal.
Glenn Allers for the respondent. May it please the court. Your Honors, the biggest issue that is not even addressed in defendant's papers is this court's decision in the Grossman case. The court will find that Grossman spoke to almost precisely the same set of facts and the analysis that the underlying motion court rendered its decision based on. The facts are almost eerily similar. Everything from the nearness of the bathing suit extraction machine, where the plaintiff was standing at the time of the accident, being not within a shower area, but rather in a common dry area. Dry area, by the way, is the term that the defendant's own witnesses use for this specific area of the locker room. So at the end of the day, it is not, the water being where it is not an incidental use, as the defendant, as the appellant argued through its papers, and as was the underlying court denied in, the underlying motion.
What about notice? How do they have notice of this condition?
Plaintiff herself testified that she advised 4 different employees of the YMCA, everyone from the front desk staff to the people who were—
Was that day? Was that the day of the incident?
It was not. It was an average of 2 times weekly for the extraordinarily long tenure that Ms. Schwarzer had been attending the YMCA McBurney facility. So it's countless times.
What's your argument that it's a reoccurring condition?
It is, Your Honor. It is a recurring condition because she complained about it. She was aware of another accident that happened in this similar location. Even the defendant's own employees acknowledged that they would encounter this condition in the dry area.
But counsel, is that defeated by Ms. Mohar's affidavit here, where she recites a specific memory of that particular day and that the condition was not present that day?
No, Your Honor. In fact, Ms. Mohar's affidavit is not very specific. In fact, that Grossman opinion that we cite throughout our papers discuss how, in that case, it wasn't specific enough where that employee, the defendant's employee in support of the motion, actually inspected the particular area every 15 to 20 minutes.
Paragraph 10 is pretty specific, I got to say, in the Mohar affidavit here. That's where she talks about being there that day. I can quote you. I was in the locker room from the time the facility opened to beyond the time that Ms. Schwarzer claims she slipped. I personally walked over the dry area many times, and there was no water accumulation, not even any slickness.
The only specific time that Ms. Mohar states that she inspected this area, the specificity, which is the specificity required in the Grossman decision, is that she says at 6 a.m. when the gym opens, when she first clocked in, she walked to this area and did not at that point encounter anything.
No, but then she goes on, as my colleague points out, that she goes on to say she personally walked over that area many times during her shift, right?
That is correct, Your Honor, and her shift is, I'm guessing, 8 hours long. It isn't, she doesn't say specifically when the last time that she checked this particular
Are you
area.
arguing that absent some kind of a log that this is fatal?
It is absence of log in the sense that a log would be definitive evidence of when somebody went through that
It
inspection.
was her job, right, to sort of look at this and make sure that that condition didn't exist. Isn't that true?
In Grossman, just like what Your Honor says, they actual material witness, the person who was charged with cleaning an area, said that they cleaned these areas every 15 to 20 minutes, and that was insufficient because in that case, that particular material witness was not able to say when the last time they checked, the subject area for the condition. And in this case, Ms. Mohar can't say it either. She can only say that several hours before, when she started her shift at 6 o'clock in the morning, when no one had been in the locker room, that it was dry. She doesn't say 15 minutes before the accident happened, or 20 minutes before the accident happened, or even an hour before.
Your position is that based on what she averred, that the only thing that we have before us is that she checked at 6 o'clock in the morning and that's it.
That is, in fact, what the affidavit says. And what I would posit is that means that the defendant cannot make out their prima facie.
I mean, we have other cases, counsel, such as that Phillip versus the YMCA and Warner v. Continuum, that says that regular inspections during that day and not seeing any liquid is in fact sufficient.
Unfortunately, in both of those decisions, there is no analysis provided on the factual details as to specifically when the inspections were done, what the time period was prior to a subject accident, when the last time that they were looked at. There isn't actually a lot of factual evidence in either of those cases to inform the court as to what kind of measurement they might consider here.
And yet, we still found it sufficient that they inspected regularly.
And Your Honor, in Grossman, 15 to 20 minutes on regularity was insufficient.
Thank you, counsel.
Thank you.
In response, I believe Ms. Mohar's affidavit.
How do you reconcile Grossman's 15 to 20 minutes being insufficient with what's here when we don't even have that?
Well, Ms. Mohar testified that she regularly and routinely.
What does that mean? Does that mean every 5 minutes? Does that mean every 2 minutes? Every 30 seconds?
She said
every 3 hours?
I believe she said continuously in her affidavit, and she never found this foot and a half by foot puddle. She was very clear in her affidavit there was no water in that area that day. The plaintiff testified that there were numerous women in the area. No affidavit, no identification of a witness, no nothing. The YMCA stands by Ms. Mohar's affidavit. It's clear, it's concise, and it's accurate. And it's consistent with the affidavit of Mr. Patel. There were never any other accidents. Mr. Ebrahim testified there was no water found that day. There were no recurrent leaks or pipes or other issues in the locker room. I contend the YMCA satisfied not only its burden, but it established it had no notice of any wet condition that day.
Thank you, counsel. Thank you both. Wilson versus Tillman and MTA.
Good afternoon again, Your Honors. Brian Isaac. I represent the appellant this time. My person, plaintiff, sitting at a light in a red bus, waiting to go, gets hit by a car. But
Mr. Isaac, if I was the defendant's attorney, I sure would want to see that surveillance video. I'd sure want to see if there were any internal accident reports. It seems to me this is premature. Discovery needs to be conducted before you can rule properly on a summary judgment motion.
Well, Judge, I'm concerned by that. Let me try to change your mind if I can, okay? The easiest answer is, as you know, the simplest one. prematurity isn't something that you say based on the fact that plaintiff moves promptly for summary judgment.
It can be done, absolutely, but just seems there's this discovery that any lawyer would want to get his hands on or her hands on.
We tried to get it. You know from reading, we tried to get it. The plaintiff tried to get it, couldn't, out of business. They didn't do anything. But here's my response. It's an easier response. The defendant knows what happened. The defendant was driving the car. I didn't see any allegation anywhere that he was unavailable. All he had to do was submit an affidavit and say, I didn't do it, or the plaintiff did something wrong, or the photos are incorrect. You have authenticated photos that show he's behind the line. So I get it. Yes, there are certainly times where a prematurity argument makes a ton of sense. But where the defendant elects not to say something under oath, anything, there is not a single statement from him anywhere except the statements he made in his MV-104, which are wholly inculpatory, the statements he made to the police, which are wholly inculpatory. Why am I waiting?
What about any inconsistencies between the affidavit, the plaintiff's affidavit and his 50H testimony?
I'm sorry.
That was my question.
I don't want to talk over you. Any inconsistency is immaterial with respect to the basic facts. The fact is the plaintiff always said he was standing there. The photos show he was standing there. The police report shows he was stationary. And there's no question from the photos that the defendant's vehicle came up from behind, struck his vehicle on, the left front portion with the back rear. He just made an unsafe lane change. There's no case where testimony is exactly the same. But you know from the Ferranti case, and even from old cases like Andre against Pomeroy, the contradictions have to be material. There's nothing immaterial about it. Here, as a matter of fact, my adversary's lead case is White against Diaz. It's a 2008 case predating Rodriguez by 10 years. I don't have to prove freedom from comparative negligence at all. So even if you take this in the worst possible scenario, and Your Honor, I would ask you not to, because the fact of the matter is that the defendant did have the opportunity to submit an affidavit and chose not to. There's no question that he was negligent. He didn't see a stopped red bus that was there at the light. The points of impact are completely inculpatory. Why should I lose this case because he didn't get something that he could have gotten, even assuming that it's relevant? Again, if there was any different fact, if the defendant had submitted an affidavit in which he controverted a material element of the case, the plaintiff wasn't stopped, the plaintiff was moving, the plaintiff changed lanes. I get it. It's a fair thing to say, but not submitting anything? And the reason for that is pretty clear. There's a huge difference between what people say under oath and what they say not under oath. Maybe that doesn't apply with lawyers with respect to the Giuliani decision, but it really is an important thing. And the truth is that people and lawyers take that seriously, and they're not going to say something that they can't say. And I think you should draw a negative inference from the fact that the defendant who's available chose not to say one thing in contravention of what my client said and what the evidence shows. Thanks for listening.
Thank you very much.
Good afternoon, Your Honors, and if it please, and if it may please the court, my name is Christopher Grimaldi for the defendant's respondents.
How do you respond to your adversary's position that any inconsistency in what the plaintiff stated is immaterial insofar as what is consistent is that the bus was stationary when he was hit from behind?
We're ignoring material facts when we say that. We're contending, or my adversary is contending.
Well, what are they? Because one of the inconsistency is the actual location. What does it matter where the location happened? What matters is that the bus was still.
Well, it matters that the bus was illegally stopped at a bus stop where it was not meant to be. The closer it was to the bus stop, and this is where the location...
So if it was illegally stopped at a bus stop, doesn't that play into his argument that it's comparative negligence? The driver would still be negligent.
I mean, I would certainly argue it's comparative negligence. When it comes to prima facie, that is a weaker position for us. I would concede that. Our driver said that he didn't see him, but the location of the vehicle would still matter because it's apparently directly at what they're describing as a sharp curve or a blind curve. And if the bus driver comes around this bend, has no reason to anticipate that another vehicle is going to be illegally stopped at this bus stop.
But that would all be great if the bus driver had put in an affidavit and said that, right? We don't even have that. Where are we getting that from?
Well, the plaintiff's own evidence is contradictory and painting this picture. The police accident report itself, which the appellant plaintiff argued was admissible shows that the red bus, their vehicle, was stopped while it was straddling over the center of the roadway. It also shows that it was stopped at this curve, which is consistent with their own driver's testimony.
You're telling us in your papers that we shouldn't give any value to that police report. So why are you relying on it?
Well, I don't think, I mean, I may be wrong.
You said it had no probative value because the officer did not observe the accident. Correct?
That is correct.
All right, so why are you arguing from it? I mean, you can convince me I'm wrong, but I don't see why you're arguing from it.
And we're arguing it because plaintiff tried to use it, which would be a waiver of admissibility.
Please continue.
But yes, in general, the testimony shows that this vehicle, it's undisputed from the record that the bus is stopped at this bus stop. There's no evidence that it was legally stopped there. We know that it's a no standing zone, so it would be undisputed that the bus was illegally stopped at this location. This location was next to a sharp turn in the roadway where our bus approaching from behind wouldn't have an opportunity to view it before it came around the bend. This is obviously a very busy intersection. It's at the Staten Island Ferry main artery. It's rush hour traffic. If our driver was being inattentive, it would still create an issue as to comparative fault because the red bus is illegally stopped in a spot where it's not supposed to be around a blind curve during rush hour in a very busy intersection. So we would argue at minimum, there's at least an issue of comparative fault. We would also argue that given our driver said he didn't see the red bus, the need for us to obtain that video is much more prevalent. Thank you, Your Honors.
In 1917, in Wiegand against United Traction Co., the Court of Appeals held that a statement that one does not see what is there to be seen by the proper use of one's senses is incredible as a matter of law. Standard hasn't changed ever. There is no merit to the claim that this is a sharp curve that somehow created a problem. The photos, 29 to 32, just look at them. It's a turn to the right. There's no obstruction. My client's in the lane. It could be my client. It could be a car. He's a bus. He's stopping in a bus stop. This is a bus lane. Why is this an illegal maneuver? There's nothing illegal about it. If you look at Mr. Culler's reply affidavit, he blew up the sign. And the sign says, no standing bus stop. This is his job. Now, if there was illegality in the stopping, they could have said it, but they didn't. There is absolutely nothing here that controverts anything that my client said. And please, look at the photos from 29 to 32. My client's bus is behind the line. What happened is, can I finish?
Please continue.
Yeah. What happened is the other bus hit him and the front fender got knocked off in front of him.
The whole grill, yeah. I saw it in the photo. Yeah.
Sure. So I just don't see any liability issue, and I also see no comparative negligence issue. Thanks for listening to me.
Thank you both. Ebrahim versus Stephen Delone. Please.
Good afternoon, Your Honors. I'm sorry, I have a little bit of a cold. My name is Robin Nichinsky. This is my co-counsel, Allison Mandeville. We represent Mr. Defendant Stephen Delone. This 440 appeal involves pleas from 2016 where the court properly granted 440 hearings but then improperly canceled them and denied the 440s based on events that happened after the 2016 pleas, which the court ruled precluded a finding of prejudice.
Counsel, perhaps put the microphone a little closer, since I know you're having trouble projecting. Put the microphone closer to your mouth, if you
Sure.
would. Thank you.
That ruling was improper. Is that better?
Right. Because she relied on the 2013 conviction.
Excuse me?
Because she was relying on the 2013 conviction? Is that what you're saying?
She was relying on
Which
something.
was on appeal at the time.
She was relying on the fact that the 2013 conviction had been affirmed not at the time of the pleas. At the time of the pleas, that conviction was still on appeal, and it did not mandate deportation. She was relying on the fact that when she granted the hearings, that conviction had been affirmed, but that's not the proper standard. As this court has held in L'Antigua, and Gaston and that line of cases, the relevant time frame to look at when deciding 440 issues is what was the situation for the defendant at the time of the pleas, not what happened later.
Counsel, are your arguments preserved?
Yes, Your Honor.
Oh.
Defense counsel filed a motion to appeal, and he said that that prejudice had not been established. And that sufficiently preserved this issue for this court. The fact,
Go ahead, counsel, thank you.
okay. So here the court denied the 440s on the ground that prejudice could not be shown due to a 2013 case that mandated his deportation at the time she granted the hearing, but that was wrong. Under Gaston, it's the time of the pleas that prejudice must be shown, not when she granted the hearings, and at the time of the pleas, the 2013 case was still pending on appeal. It was not correct to say that at that time, the defendant could not have shown prejudice.
Can this court go on to do an analysis under PK of our own to determine whether under PK, I always pronounce that name wrong. But
PK.
in other words, you know, in determining whether there's been prejudice, there's a number of factors in PK. And should we evaluate those and make a determination, or do we have to remand it?
Well, the court just under Peke has to warn the defendant that he might be deported. Peke wasn't really implicated here. These 440 motions challenging the 2016 pleas were based upon allegations of misadvice where, according to the defendant's pro se motions, and they were pro se motions, and the court knew that and gave it a little leeway because of that, as she should have under the law, he alleged that he was misadvised and he was not told that his plea would mandate deportation at the time, his 2016 pleas. I want to just...
Counsel, the lower court didn't undergo the analysis of considering whether the defendant, had he been properly advised, would have proceeded to trial, correct?
Excuse me, I'm sorry.
The lower court did not analyze whether the defendant would have proceeded to trial had he been properly advised with regards to immigration.
No, she
sidestepped that.
She granted the hearing in order to decide that, but then she didn't. Then she rescinded the grant of the hearing based on prejudice, only on prejudice.
Right, only on prejudice with regards to that 2013 conviction.
Correct.
Right. In light of LaFontaine, what can we consider?
In light of LaFontaine.
In other words, what was the adverse ruling for the defendant in this case?
Well, the adverse ruling was the incorrect ruling that he couldn't establish prejudice on his 440s relating to the 2016 pleas.
So if we find that you're correct on that position, that ruling was incorrect, what's the proper result here?
The proper result is to reverse the denial of the 440s and remand for the hearings that were properly granted in the first place. That's the relief that we seek here.
Thank you, counsel. You have time in rebuttal.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the Office of Darcel D. Clark. Your Honor, the Court made a record-based determination that his 440 motions would fail. And it's based on the
it's based on, let's assume that we believe that her position that he's not prejudiced because of the 2013 conviction, let's assume that that's wrong.
Mm-hmm. So the totality, so to give some background as to what the determination was based off of, the court indicated that she reviewed the in-camera, the unredacted legal aid files. In those files, there was a note in there that did deal with the 2013 conviction, which ended up blowing up the entirety of defendant's pro se claims altogether. And that fact was immigration counsel was involved during the pendency of defendant's of the 2014 indictment, which he ultimately pled guilty to a reckless assault.
And you're saying she didn't know that when she initially ordered the hearing? She was unaware that immigration counsel had advised the defendant?
I would say, yeah.
Do we know that?
I would submit that she was aware of it because she took the plea in the 2014 case.
Yeah.
And in that 2014 case, when she did take that plea, the court managed to take a lesser included that was not initially charged in the indictment, which was initially meant for an intentional crime, but he pled guilty to a reckless, which was added on pursuant to Criminal Procedure Law 220.20 sub 1 sub A. And defense counsel stated that pleading to the reckless was within the defendant's interest. That was a sign that this added on plea to a reckless crime did have some benefit to it. And in her decision granting the 440 hearing, she makes a point that under the recent case law at that time of Sessions v. DiMaia, the reckless assault was probably not going to result in a crime, it was not going to be an aggravated felony for purposes of deportation. And the result of his deportation ultimately was the commitment sheet error that listed his conviction of being an intentional assault as opposed to a reckless assault. So and in that written decision, Justice Best ended up outlining, implied that the legal aid was effective at providing a potentially non-aggravated plea, that but for the commitment sheet error, this would not have resulted in the NTA. And the same could be said about the SCI.
Counsel, but her decision relied on that there was no prejudice because of the 2013 conviction. And I take it that you're not disputing that conviction at the time was under appeal.
At the time, it was under appeal, but even then, because the courts in both pleas made it very clear that there were potential immigration consequences for his pleas, it did not stop the defendant from pleading guilty. And there are
is the question what the court did, or is the question the advice that he got from counsel? Under the abuse of discretion, we'd say that given the information available to the court at the time, was there a basis to believe that the defendant's claims were meritless? Defendant argued. I want to understand your argument. Is it your argument that the Supreme Court's position in considering the 2013 conviction, despite the fact that it was under appeal, that was proper? Or is it your position that it wasn't proper, but there was another basis on which to deny?
I would submit that under the totality of the circumstances, all of it was they considered all of it, and the fact that
including the conviction that was under appeal.
I would say so, because that particular fact that the in-camera inspection showed that legal aid immigration unit attorneys were present during the entire pendency of his case, and that advice that was pointed out was successful. By legal aid filing the late notice of appeal and having it granted, it prevented that conviction from showing up on his notice to appear, because again, the federal government needs finality with respect to a conviction in order to serve as a basis for deportation. And Your Honor, the last thing
Thank you, counsel. Does anyone have any other questions? Thank you.
I just asked that one last point.
Counsel, you can sit down now. Thank you.
I just want to quote from the judge, and she clearly, in dismissing the 440, says because defendant was deportable, he cannot, in any event, meaning because now his 2013 case has been affirmed, now after the pleas, he cannot establish prejudice in these two cases no matter what advice he got from his legal aid lawyers. So it's just wishful thinking.
And that's a total holding, right?
That's her ruling.
That's her ruling.
Yes.
It wasn't based on anything else.
Right. It's just wishful thinking that he's trying to say it covered everything. It didn't. She ordered the hearings because she wanted to understand the misadvice claim initially because there was contradictory statements in the record about it, and that's why she had ordered the hearing. I just want to, before my time runs out, rebut a couple of improper assertions or inaccurate assertions in respondent's brief. These 440 appeals matter very much to our client today. In fact, his immigration case was reopened. He is now, again, a lawful permanent resident. His immigration case was dismissed. He was actually never even charged with that 2013 case. He was deported because of these cases that are before you today. So your decision really matters to him. He can come back to the country, but when he gets here, he could be charged with removability again. And if you give him the opportunity to have his 440 motions, to have his 440 hearings that were properly granted in the first place, you give him a chance to show that that the 2016 pleas were in fact unconstitutionally
Counsel,
obtained.
he also has an appeal, does he not, from the 2013 conviction? Or not an appeal, pardon me, quorum nobis, perhaps?
Yes, there were two things happening
involving-
with that. One is
right,
the
we
Minter
already did the
case,
appeal.
which no longer makes it mandatory deportation anyway.
Right.
The other is that I have a quorum nobis before this court right now. It's been pending for quite a while. And in the quorum nobis, we challenged the 2013 case on the grounds that it was ineffective assistance of counsel for legal aid to file an Anders brief in that case, and I have an admission by the Legal Aid Society that in fact it was ineffective assistance of counsel.
Thank you very much. Thank you both.
Thank you.
Thank you. Museum Building Holdings versus Shriber.
Good afternoon, Your Honors. Kevin Nash for the appellant. This is a process-based appeal in terms of raising objections and challenges to summary judgment. We raised a service defense. We raised a performance payment defense.
What do you want to start with?
I want to start with what I think is the critical issue. That is the application of RPAPL to out-of-state foreclosures. This foreclosure sale was done effectively on 1 day's notice. The bankruptcy was dismissed on December 5, 2022. At the time of the bankruptcy, there was a foreclosure process stayed in California. The foreclosure sale occurred the next day, December 6, without any noticing, without any remarketing. There was a deficiency action in play at that time, and the award was the difference between the credit bid of the lender, $200 million approximately, and the value of the debt, $270 million approximately.
Yeah, but haven't we held that that section of the RPAPL does not apply to out-of-state foreclosures?
Okay, so let's drill down on
You're asking us to reverse ourselves.
No, I'm not. I'm asking you to make a distinction. You have held in Lombardo, it doesn't apply 1371-1 on a 90-day statute of limitations to bring a deficiency claim. Most of the cases that talk about out-of-state foreclosures talk about not 1371 per se, they talk about the one action rule, 1301. That means you can't sue simultaneously. You make an election of remedies. This is a substantive defense. This is a core policy defense that under 1371-2, that a deficiency claim is not necessarily the sales price at an auction, but fair market value. And that is a key distinction. You have never...
But we don't seem to make that distinction in Taylor, Bean, and Whitaker Mortgage Corporation.
Yes.
Do we?
But that wasn't a deficiency claim. That was a 90-day rule claim.
Right.
That was under 1371.
I know, but we were kind of categoric in our statement, though.
Well, you
And
followed...
it did actually apply to 1371 sub 2. I mean, it's in the decision.
You applied it, I think, on a procedural ground. You followed Lombardo. I cited Union Realty in the second department, which offers the analysis that you should make somewhat of a conflict of law type analysis. Which state has the greatest interest? This guarantee governed by New York law. This guarantor, New York resident. So I believe that the basic protection under the real property law of a deficiency claim being based upon fair market value should apply. Why would you make a distinction if the foreclosure happens in New York City as opposed to New Jersey or California. The same rule that there is not a fair market evaluation should apply no matter where it goes. If the parties agree New York law applies, and if the guarantor is a New York resident.
Didn't the defendant waive this express defense?
Not this. This is not a defense. This is a reduction of the judgment. This is not a defense to the guarantee. I want to make that distinction. The liability is there. It's the question of how much. And you got to apply, if it was a New York foreclosure, no doubt, you would apply fair market value.
Didn't it also waive calculation of the debt?
Not this is a defense. When you look, he didn't waive anything statutorily. He is entitled under statute to that benefit. So that applies no matter what. It's amount of the debt as compared to the value of the collateral.
I just want to follow up on what my colleague said. Guarantor waives all rights and defenses that such guarantor may have because the debtor's debt is secured by real property. I'm just going to skip to the subdivision. The amount of the debt may be reduced only by the price for which that collateral is sold at the foreclosure sale, even if the collateral is worth more than the sale price.
That statement runs against the policy of New York State. Now, we used to have...
What's the case law on that?
We used to, with the history of the statute, we used to have a statute that says deficiency was calculated based upon sales price. The legislature changed that. The whole adoption of 1371-2 is based upon the policy of this state that the deficiency claim should not be the difference between the sales price, which is artificial. It should be a difference between a true fair market calculation. So I think that's a policy issue. I think all these waivers and these guarantees, when they confront important policy issues, we should give effect to the policy issue, and we should give effect to the New York law governance. I see my time is up.
You have time in rebuttal, counsel. Thank you.
Good afternoon. David McTaggart for the lender, Museum Building Homes, LLC.
How do you respond to your adversary's claim that the express waivers here should give way to the policy behind the law?
The appellant signed a contract. He's a sophisticated party. He's represented by attorneys. This is a 9-figure loan transaction, $218 million at the time he executed the guarantees. He's a sophisticated party, entered into this openly, willingly. The guarantee expressly states, as a condition to us extending $200 million to the borrower, you need to execute this guarantee. These provisions are carefully negotiated. In fact, this is the first time we're hearing that this is contrary to public policy. But, you know, one, that's a question for the legislature.
Can you raise the mic a little bit, please?
Yes. That's a question for the legislature, if this is truly a public policy argument. It's been settled since the 1930s that this statute applies specifically to properties within New York State. The Court of Appeals in the Steinmetz case we cited raised a rhetorical question. How can we at courts of New York dictate how another state handles their foreclosure proceedings? That's real properties beyond a New York court's control.
Yeah, but the other side would say, I guess, he's probably going to say this in rebuttal, that we're talking about a guarantee here in New York State. So it's not affecting the foreclosure in California.
I beg your pardon?
So it would not affect the foreclosure in California. We're just talking about a guarantee.
But his challenge is to the foreclosure process. The first thing he said when he stood up here is he challenged the timeliness of it, which, by the way, and we put this in our papers, it's completely consistent with California law. The trustee gave periodic notices as required under 2924G of the California Civil Code. The trustee gave timely notice once the sale was disrupted on August 9/22 by virtue of the filing of the bankruptcy case. The trustee gave periodic notices as required by the statute, and the timing worked out that the sale was scheduled already for December 6, 2022. It so happened that the appellant dismissed the bankruptcy case the day before the sale went forward. Notice was given. He could have participated. Others could have participated. It was completely consistent with California law. There's an express waiver of any challenges to this. This is called a Gradsky waiver under California law. It's been upheld. It's been upheld by courts applying where the loan documents were governed by New York law, and we cited that case in a footnote in our brief. California courts have held that The guaranteed debt, a deficiency can be determined by a credit bid, and Mr. Shriber agreed to that within his guarantee. This is a straightforward, he may not want to live by the contract that he signed, but New York policy, fundamental New York policy, which we put at the tail end of our opposition brief, is enforce the sanctity of a contract here. He signed the contract, he should be bound by the words that are in the contract.
And what about the opposition papers being not accepted?
Well, they weren't accepted because Mr. Shriber did not timely respond. We believe insufficient proof, insufficient excuses were provided. We don't think that he satisfied CPLR 3112D. We believe that's the trial courts correctly found that he did not satisfy 3112D, and that creates an abuse of discretion standard. We think that this court can readily affirm the trial court's decision as a result of that. And if the court has any questions about service of process, Mr. Schriber's sole...
You've got some time if you want
to
argue prophylactically. He hasn't talked about service yet.
Well, I just want to make clear, we've got a process server who had been to his house 7 times before serving the papers, had seen Mr. Shriber at the door. He introduced himself about a month beforehand, 2 months beforehand.
That may be true, but on this date, process server left it on the wrong door is the allegation.
It's not the allegation, actually, Your Honor.
Okay.
It's an insinuation.
Insinuation.
It's an insinuation. The only facts, if you look carefully at this affidavit, it's very carefully drafted. It says, I never found papers affixed to my door.
Or it wasn't given to him by whoever the other...
Or it wasn't given to me by my neighbor. Those are the 2 facts. There's no proof that they were ever affixed to the neighbor's door. I don't know who this mysterious neighbor is, but certainly the law would entitle him, and I think require him, in order to rebut an affidavit of service from a process server. Perhaps the neighbor could come forward and say they were affixed to my door. If that were the case, then we would be looking at a different situation here. All we have is a flat denial, and this court has consistently held that's insufficient to rebut the process server. Thank you for the court's time.
Just briefly on service, the affidavit says I didn't receive the papers, they weren't affixed to my door, and my neighbors never gave me any papers that might have been affixed to his door. He put into play that he didn't get served with process. When he learned about the lawsuit, I did make a motion to extend the time to file opposition papers. I put into evidence that there was, in my mind, a viable, credible challenge to service. That should have been done through a traverse hearing. There was 2 conflicting affidavits. The affidavit of the process server was hardly dispositive of anything, and yet the trial court found it without taking a shred of evidence. So I think there's an issue on service as well. As to my second point, this court has had this issue umpteen times. I actually read a decision this morning on it. This payment versus performance under 3213 that came out this morning. The payments performance, that's the express terms of this guarantee. The lower court said, well, even though it says performance, you're really paying a debt. The performance here was springing recourse covenants, multiple. I think there's 17, 18 of them. Why this guarantor got in trouble, he didn't perform in the sense that he filed a bankruptcy when he couldn't have. That is an event, it's a performance event. Whether or not summary judgment applies, it doesn't apply in 3213 context because it's payment and performance. So if you're gonna use 3213, which I think you use it very narrowly for payment defaults, when you expand it to include potential springing recourse events, when there's nothing in the document says 3213 should apply, I think that's an overexpansive use of that. So I do have the service challenge, I have that challenge, but counsel said sanctity of contract. I say sanctity of the statute. That statute on a deficiency claim is the policy of New York that the sales price is not controlling at a credit bid.
Thank you, Counsel. Matter of Uniform Firefighters Association versus City of New York. Please.
Good afternoon, Your Honors. May it please the court. My name is Paul Linzer. I am the labor counsel for the Uniformed Firefighters Association, the public sector labor union that represents about 8,500 firefighters, fire marshals, and Marine Division pilots and engineers. Your Honor, this appeal concerns the wrongful denial of the right to go to arbitration. This appeal concerns the situation where UFA members were placed on involuntary leave without pay because they did not fulfill the city's COVID-19 vaccine
Counsel, so
mandate.
many courts, federal and state, have found that to be a condition of employment. So how do you get around that?
Well, Judge, I understand the argument of condition of employment, but the issue in this case is not that the UFA is challenging the condition of employment. The city and the Board of Collective Bargaining have referred to the complaint of action by the UFA as a violation of the vaccine mandate. Let me be clear. The UFA has never challenged the vaccine mandate. The underlying action here was the contractually bargained rights for pay, night differential, longevity, other economic categories in the collective bargaining agreement. The definition of a grievance under the collective bargaining agreement that has existed for many decades deals with a misinterpretation or a misapplication of sections or sections of the collective bargaining agreement, or a policy if it's not the collective bargaining agreement. In this case, the complaint of actions were the involuntary placement, first of all, on leave without pay. That dealt with the FDNY Regulation 17. The Regulation 17 certainly contemplates leave without pay, and there was a clear nexus between the complaint of action of being placed involuntarily on leave without pay with the grievance, the scenario of the involuntary action versus the requirement under the regulation that only contemplates voluntary. So
You're saying that's the only time that you can have leave without pay?
under the FDNY regulation, the regulation only contemplates a voluntary leave without pay. There is certainly, Your Honor, involuntary leave without pay that has existed in the fire department.
How is that relevant to an allegation that you're not meeting a condition of employment?
The underlying issue is the violation of the contractually bargained rights. We are not, once again, challenging the condition of employment. This is not...
You're saying that they could have done anything but put you on leave without pay?
There were other alternatives for the city.
And leave without pay is not one of them, because that has to be, the only thing that's authorized is when the firefighter or the member applies, for lack of a better word, for leave without pay.
If the firefighter applies for it, then they have voluntarily requested leave without pay. But when it's involuntary, we're saying that was a misapplication of the regulation. That's a classic grievance. That's the issue for the regulation, the policy application. For the collective bargaining agreement, it was the simple leave without pay. The pay provisions of the collective bargaining agreement, once again, was the underlying complaint of action, that these are members in the city, public sector employees with a bargained for contract, with a solid collective bargaining agreement. The vaccine mandate, although temporary, at no time during its pendency did it wipe out the New York City collective bargaining law. It never wiped out collective bargaining rights. It never wiped out the rights of the members of this union to go to arbitration. And the other thing about condition of employment here is where this court should be very troubled. This court should be very troubled by the condition of employment argument as the basis for denying the right to go to arbitration and have an arbitrator consider the contractual violations or the policy violations. Because the city is the same party here as who proceeded to arbitration with other unions on essentially the same COVID vaccination leave without pay provisions. In fact, in the same agency, in the fire department, the fire officers union, the Uniform Fire Officers Association, the UFOA, filed essentially the same grievance. The same COVID mandate, the same agency, essentially the same grievance. The only difference is they have their collective bargaining agreement with their contract sections on economic provisions, and the UFA has their economic provisions. But essentially, they're the same. And how can the city proceed to arbitration in one forum and then say in this forum, the UFA members have no right to go to arbitration? If it's a condition of employment for the UFA members, it should have been a condition of employment for UFOA
You make
members
that
or
point
other
in your
unions.
brief, counsel. Thank you.
Thank you.
You have time to rebuttal.
Good afternoon, Your Honors. Brian Zapert for the City Office of Collective Bargaining. So to begin with the issue of whether or not the vaccine mandate constitutes a condition of employment, the board has long held that conditions of employment, whether a vaccine mandate or not, do not give rise to arbitration rights. That would be the same for a position that requires a driver's license or state residency. That's simply the rule. It was applied in this case as it has been in others concerning other conditions of employment.
So how do you respond to your adversary's position that pursuant to the bargaining agreement, that a member could only be put on leave if they request that, and that for violation of this condition of employment, that they cannot be denied pay?
So concerning the Regulation 17, the special leave provision, the Supreme Court in the underlying decision held that that particular regulation did not encompass all scenarios and circumstances in which leave without pay can be implemented. So similar to the board in this particular case, the board read Regulation 17.5.1. It's titled Special Leaves. I won't go into the precise text, but it
Well, in the
only-
precise text, it does say that that kind of leave is made in writing by the applicant.
Correct. It also states minimums and maximums and that they need to provide a reason, but every single type of qualification, that section, in short, is about voluntary leave only. It does not concern involuntary leave. And in writing its decision, the board simply looked at the text and observed that, and the Supreme Court correctly
The
upheld
fact
that.
that there's a process for the firefighters to apply for voluntary leave doesn't necessarily mean that eliminates a process for involuntary leave.
That's correct, Your Honor. Indeed. So moving on to the issue mentioned by appellant's counsel concerning the other arbitrations that were concerning allegedly similar unions and agreements, that speaks to the board's jurisdiction in this sort of matter. And
Or does it mean that it was maybe arbitrary? Because what's the basis? If you did it for other unions, then why not do it here as well?
right, the statute, Your Honor, states specifically that the board can review petitions challenged by a party. We cannot simply challenge arbitration on our own. It's beyond our jurisdiction, and I'll leave the rest of that argument to respondents' counsel, assuming they have something to say about it. So in short, appellant has identified no reason, whether legal precedent, statutory, or policy, that the board erred in its determination that these particular provisions were not arbitrable, nor has the appellant identified any reason that the Supreme Court was wrong to uphold it. So unless Your Honors have any questions.
Thank you, counsel.
Thank you.
May it please the court, Jeremy Schwarzer for the City of New York and the Fire Department of the City of New York. 3 independent entities have looked at the UFA's remaining grievances in dispute. They've all found them not arbitrable. This court should affirm and find the same. The UFA has the burden to show that a CBA provision or an FDNY policy has required nexus with the complaint of action, which is placing FDNY members on leave without pay status for failure to follow the vaccination policy. What that means is that the UFA has the burden to establish a source of right within the CBA that has been violated by placing members on involuntary leave without pay, and they haven't done so here. In fact, today—
So the CBA, it does talk about, it has guidelines for investigations, interrogations, trials, and hearings. So just hypothetically, and this is what I understand their argument to be, isn't a request for a opt-out of the vaccine requirement one of those? Doesn't that lead to an investigation?
It does not. It is that they have not claimed that this is not discipline in that way. And in fact, I read their briefs as, in fact, walking away from all that. I don't hear them saying anything that this is really about the disciplinary procedures and that they were entitled to these disciplinary procedures.
I see. And that all the things I mentioned, those investigations, interrogations, are all anchored to disciplinary proceedings.
That's right. Okay. And this is a condition of employment, well established. They don't dispute that at this point, even though I think That is really what this complaint is about, is that they think that this should not have been a condition of employment that was imposed on them. I think that's where this is really coming from, and it reads their briefs that way.
Does the
But
CBA have a process for placing a firefighter on involuntary leave?
the CBA doesn't talk about it at all. And that's the issue, is that they can't identify a source of right that is arbitrable. They have admitted that the permissive leave without pay, that's in there, and that is different, and that would not apply at all to involuntary leave without pay. So the absence of language that you can point to in the CBA means that there is no source of right. That is the key thing. You need, if it's not in the CBA, it's not arbitrable, because the parties have to agree to these provisions, and they agree that the provisions that are there are arbitrable. If it's not there, there is no source of right that leads you to it. I think this is pretty clear cut. And in terms of financial provisions, again, the CBA does not allow for people to earn certain base salary, certain other types of remittances when you haven't worked. That's not in the CBA. And it's a pretty straightforward analysis. I would say they haven't met their burden on this. If there's no further questions, I have nothing more to add.
Thank you, counsel.
Thank you.
Your Honors, the UFA has immensely met its burden, because this is the gatekeeper function. The arbitrability determination is the gatekeeper function, first of the Board of Collective Bargaining and secondarily of the Supreme Court. The gatekeeper function is only to determine, is there a reasonable relationship between the act complained of and the contract section? When the act complained of is depriving a member of pay, we point to the contract section that says there's a collectively bargained wage. When the act complained of is taking away other economic provisions, like I mentioned before, night differential, longevity, other economic provisions, the complained of action is clearly set forth by saying you can't take away a collectively bargained right. The nexus that has been established is the mere gatekeeper function, and the nexus is overwhelming in this case. That's the standard here. The condition of employment is a bit of a red herring, because the condition of employment is the vaccine mandate itself. And when the counsel for the Board of Collective Bargaining raises this issue about the condition of employment and that it precludes arbitrability, interestingly enough, the board didn't do any analysis of its own case law, because they cite to the case law where you would know before your career even starts that there's a residency requirement, as he mentioned in the case law, or a driver's license requirement, as the case law requires. Those conditions of employment are known before somebody's career starts. But when this falls out of the sky in the, for example, 15th year of a firefighter's career, they have a collectively bargained right to complain about the fact that there's a regulation that says leave is acceptable if you voluntarily request it. But it's a misapplication of the policy to place a person on involuntary leave. We established the nexus for the regulation. We clearly established the nexus for the economic provisions in the collective bargaining agreement. It's an overwhelming establishment of the nexus. It's in the record. The request
Counsel,
for arbitration.
if I may, I just want to go back to what Counsel just indicated about there's no CBA provision that allows, compensation when you're not performing any duty. So what's your response to that?
Of course.
And particularly the condition of employment.
Yeah, yes, I understand, but they are reframing and mischaracterizing the UFA's request for arbitration. The UFA's request for arbitration dealt purely with the contractual violations or the policy violation on the leave issue. The issue of their distortion or their mischaracterization is that there should be a collectively bargained section for rights to continue if you don't fulfill a condition of employment. Of course that section doesn't exist. Nobody ever collectively bargained what would happen if you didn't fulfill a condition of employment, because as I said, the case law deals with conditions of employment that existed before you even got hired, like the requirement of a license or the requirement of residency. Thank you so much.
Thank you, counsel. Thank you all. Valley National v. 252 West 31st. Please.
Good afternoon, Your Honors. James Andriola on behalf of the plaintiff appellant, the mortgage lender. This case, the lower court erred because it failed to follow the mandate of Flushing Savings Bank versus Bitar.
In that particular case, there had been a submission of an appraisal from an appraiser who maybe miscalculated or didn't submit sufficient proof to show the market value. Here, in this particular case, you didn't submit anything to show market value. It was just the referee's report and the deed. And so if we were going to follow Bitar and also the statute, why should it be allowed that you could submit nothing? I'm not even going to say the bare minimum because it was really nothing. And then at a later time, get to supplement that without leave of court and it be okay. I mean, we'd be opening the floodgates on these kind of cases.
Okay, so the idea, and the judge ruled this as well, and that's another reason we think he erred, because he said we didn't present any evidence of market value. We presented him case law at the appellate division level saying that the price generated at an open auction and paid for by a bona fide purchaser for value is certainly evidence of the fair market value of the property.
Also,
So that's Adirondack, I'm sorry, just to make sure, that's Adirondack you're arguing?
Correct.
Okay, go ahead.
Also, but the RPAPL itself makes a distinction between the auction sale price and the fair market value, correct?
Correct.
So they're not the same.
But it is still evidence of some kind of the market value of the property.
It's evidence of what it's sold.
Yeah, it's not a situation, I agree with you, it'd be a totally different situation if I go to the sale, there's no third-party bidders and the bank takes it back. Absolutely, that would fall under your example that there's zero, bare minimum, no evidence. Here, this is a sale that was advertised, bid on, and a winner took it and paid $2,851,000 out of their pocket to
That
say
was just
that's
a little
not
bit
evidence
above
of value.
Counsel, was that just a little bit above the upset price, or did I misread the record about it?
It's a little bit above the upset
What,
price,
about
yes.
$1,000?
Exactly $1,000 above the upset price.
Please continue.
And then the other, I don't know why in the judge's opinion, he does say the bid was below the upset price. I don't know where that came from.
It was very close to the upset price. Anyway, please continue.
And
so, but why didn't you move, all right, I'll ask the question that sort of out there. Why not move to supplement your motion papers rather than just sort of present them to the court? Some might say dump them on the court.
well in advance of the return date, the other side had asked for an adjournment. That courtesy was given. And during that period, we filed the appraiser's affidavit. It wasn't ready at the time when we filed our initial motion papers.
No, but there are procedures for getting it into the record. And Judge Pitt-Burke's point is that we're going to just be opening the floodgates here to people having do-overs all the time. And that's what we don't want to do.
Okay.
So in Bitar is slightly different because they did submit something and it wasn't enough. And the Bitar court found that they should have been allowed to supplement. But they at least gotten in from the get-go the idea that there was another way of appraising evaluating the market price.
And I addressed this in my reply. I don't read into Bitar that there's like a threshold we failed to meet that's implicit in Bitar. It just says, the exact words of the court is, if the lender's proof insufficient in the first instance, it must give the lender an additional opportunity.
Insufficient in the first instance is different than nothing in the first instance.
Again, I mean, a bona fide...
Why not move for leave?
Well, after this ruling, there was a motion to re-argue and renew, but that's not... I can't appeal those decisions, so that's not before you. But the way I read Bitar, it required him to permit us to submit additional evidence, and it was already on file.
Irrespective of what you filed or failed to file with your motion. Is that your position?
Yes.
Okay, counsel, you have time in rebuttal. Any further questions? No. Okay, you have time in rebuttal.
Good afternoon, Your Honors. Just one other thing I'd also like to point out is that the appellant also invited Justice Kahn to make a decision based upon what was before him when they said that even if the appraisal that they submitted later without any leave to submit it later wasn't considered, that they should still rule in favor of appellant. Well, of course, if you're inviting the court to make a ruling based upon just the papers you filed with your motion, and this, I believe, is the only time I've ever seen an attorney file papers and then some more a couple of weeks later and some more later. I've seen pro se's do it. I've never seen an attorney do that. But they invited the court to commit what they're calling now error by deciding, based upon their notice of motion that was filed the first day they filed it, and the opposition and their reply, which they did have a chance to put in a reply, and not to consider their supplemental papers that they filed without leave. So they can't call it appeal. I can't call it error now, and they're asking the court to overturn Justice Kahn based upon something they never asked him for. As your honors have said, they never asked him for leave to file their supplemental papers, so it certainly shouldn't be considered error that that they didn't get relief that they never asked for. And I'd like to point out, of course, your honor mentioned Adirondack. That holding said that there were 25 to 30 other bidders. So I think that's a very different situation. The other one involved a ski resort in Cortland County. I believe there's only maybe 2 of those, and perhaps the other one hadn't been sold. So there's no comparables to this, which there would be in this case. If the court has any other questions.
Let me ask you about Bitar a little bit more, because it does seem to contemplate the possibility of a second shot. You know, what I said, a second bite of the apple, which makes it sound illegitimate. But footnote 2 says, it assumes that the applicant can be given an additional opportunity to submit necessary and relevant proof. I mean, is that true in all instances?
There is a possibility of that, although I would say, first of all, this appellant invited the court to make a decision based upon their motion as originally filed and my opposition and their reply. They said even if the appraisal was disregarded, the court should still make a ruling in their favor. Well, the invitation to make it in their favor also includes the invitation to make a ruling other than in their favor. So they certainly shouldn't be able to be heard to say that something's error now that they invited Justice Kahn to do. And as Your Honor also pointed out, they submitted nothing to start this with. They didn't just submit the person in Bitar. The bank in Bitar had submitted substantial proof, but it was found to be insufficient. But they submitted absolutely nothing, and there is, as Your Honor pointed out, a difference between the appraisal value and the sale value, the real value and the sale value. I believe that the Justice Kahn's decision.
Just to go back, just to pick up on what my colleague said, you know, and I'm paraphrasing, you know, second bite of the apple, right, Bitar. But how should we look at the language of the statute, you know, RPAPL 1371 subdivision 2, because it says the word shall twice, that the court shall determine the fair and reasonable market value. Then I'm skipping, right? And then shall make an order directing the entry. So what about, you know, second bite of the apple, right, to submit proof, because the court shall determine the fair and reasonable market value.
Understood, Your Honor. Yeah. I would also say that they did, in fact, invite the court to make a decision based upon what was before the court, just in terms of their motion. So I don't think that they should be able to be heard to say that it's error to do the very thing that they invited to do. If the court were to send it back somehow, which I certainly think the court should not, then both sides should be given an orderly opportunity to submit additional documents, not just a ad hoc, pell-mell running series of submissions from one side. But I do think that they failed to even submit anything. So there's nothing for the court to go on when the movement doesn't even submit anything in support of their motion. I don't think that the motion is really before the court, because it hasn't.
You've made that point very amply. Thank you.
Thank you, Your Honor.
I'll be very quick. And the point Your Honor just made about the shall language, that's in our moving brief, or opening brief. I think that actually, I'm not going to tell you what you already said.
How many times should that be allowed then, right? If the statute said shall, and we're going to be reading it, shall, you said, okay, here's your second opportunity to submit something. Well, that's not enough. Here's your third opportunity. Keep going. How long? When do we end that?
Well, the Court of Appeals hasn't weighed in on that, but they've definitely weighed in on you get 2 shots at the apple or 2 bites at the apple.
Doesn't shall refer to, doesn't it presuppose that the parties are going to give you something to decide it on?
So it's your position that the referee's deed and that sale, that was something, that did give some evidence of the value?
A businessman business person went to the court that day and agreed to pay $2,851,000 for this property after it had been advertised for 4 weeks. The idea that I presented nothing to the court.
With regards to fair market value, so if someone had gone and paid $20 million for it, that would have been fair market value?
Well, yeah, it might have been. I mean, there'd be a whole different property.
So anything that gets paid is fair. So in other words, you're saying as long as I give you what was paid at the auction, that's enough. Despite the fact that the law itself makes a distinction between sale price and fair market value.
That is some evidence of value, and if the judge found that insufficient...
Evidence of value. The question is fair market value.
It's fair market value. I mean, the price paid for Coca-Cola stock yesterday on the stock exchange, I would argue is fair market value of what it's worth, because someone was willing to pay that much for that stock.
But you're saying nonetheless, you gave further evidence and that your client should have an opportunity to supplement based on Batar.
Yeah. If the judge found my analysis about the Coke stock is not sufficient enough for him to make a ruling under the shall standard, then direct me or permit me to submit additional evidence. This case, that additional evidence was already on the docket.
Thank you, counsel. Thank you both.
Thank you, Your Honors.
Thank you.
AEB Commercial v. Holtzman. Please.
Good afternoon, Your Honors. If it please the court, Janine Gettler appearing for the appellant. Your Honor, this matter brings another matter before the court pursuant to CPLR 3213. Our client executed...
But here you've got it seems to me a big hurdle, which is that the defendant acknowledged that the guarantee was an instrument for the payment of money only. He said it. So 3213 applies, no?
But, Your Honor, in that guarantee that he signed, it does say that he has other obligations beyond simply the guarantee to pay the lender money. In that obligation, it includes paying leasing commissions, which would not be money paid to the lender. It also obligates him to make sure that build-outs for leasing, for rental leasing, is also paid, and that's on page 172 of the record.
Was there any waiver by the guarantor to assert that it wasn't for money only?
I don't think that he waived that.
Inside the guarantee? It doesn't say that?
In the guarantee itself, he obligated himself to ensure that leasing commissions were paid and that build-outs were paid. Those would be monies paid to someone other than the lender, obligations to ensure that things were paid to others. That is not a guarantee for the payment of money only to this lender.
Also, this additional performance that you speak of, was it a condition precedent to the repayment?
It was a condition precedent to repayment, yes.
How?
Well, these are obligations that would arise during the course of the term of the
They're separate obligations, aren't they?
I'm sorry, Your
They're
Honor?
separate obligations, not condition proceedings, right?
That's true, Your Honor. It is a separate obligation, but it is an obligation nevertheless that takes it out of 3213 because it's not simply a document which obligates this defendant to pay the lender a set sum of money. It doesn't say anywhere that the obligation to pay these leasing commissions would be deducted from the $9 million cap on this loan, for example. I believe that the case of PDL Biopharma versus Wohlstetter, 147 AD 3rd 494, in which this distinguished court in 2017 found that if there is a guarantee that has additional conditions to it, additional requirements to it, that it falls outside of 3213.
But in that case, it spoke about payment and performance, right? How does that relate to what you're talking about?
Well, here the performance would be ensuring that the borrower, for example, paid its leasing commissions, or that the borrower made sure that build-outs were conducted, that contractors were hired, that the retail leasing spaces were built out appropriately. That's precisely the kind of performance that takes it out of 3213. In addition, I don't think that you can look at this guarantee in and of itself to determine the sum or the obligations that are imposed upon the guarantor. In fact, the loan agreement, the amendments to the loan agreement, and the note are instruments that are integral to determining how much this borrower had to pay. The note, for example, was required in order to determine what the requisite interest rate would be on costs, and that would be sums that were due in addition to the $9 million. The note was not even presented to the court below. It was never put into the record, and it's required in order to determine what that interest rate would be.
The note wasn't in the Kaken affidavit or Katzen affidavit? I'm sorry, the affidavit proffered by the other side, it didn't include the
The
note?
note was not included with that affidavit. It was never sworn to, and it was never presented. So I believe, Your Honor, that these instances bring this case within the Wallstatter exceptions to having 3213 be the instrument that can be used to have judgment entered immediately upon this defendant. I also want to note that there's no default notice ever to the borrower or to...
Is that required, though?
I believe that it's required under the guarantee, Your Honor. There are instances in the guarantee itself where it says upon demand, and there was no
Right, but that doesn't apply to what's happened here, right? Because it was broken into two specific parts in that particular guarantee as to whether or not notice was required, right? An event of default could be when it's not paid by the maturity date, or if it's not paid and such non-payment constitutes a 5-day where there's following notice and notice secured. Those are two separate things. But here we have the loan not being repaid by the maturity date. That part of the agreement does not require that there be any notice.
That point is well taken, Your Honor, and I believe that you are correct there, except that amounts payable to the lender shall be due and payable upon demand. And in paragraph 2A, again on page 172 of the record, seems pretty clear that there should be some sort of demand to the borrower. In addition, there was a letter sent to the borrower and to the guarantor on July 12th, 2023, days before the supposed maturity of the loan, saying that the lender would agree to extend the loan. So the guarantor had no notice that it wasn't extended, that his
Thank you,
obligation
counsel.
would come due.
You have time in rebuttal.
Thank you.
Good afternoon, and may it please the court. John Gwaley with A&O Sherman for the plaintiff respondent.
Counsel, can you just start there with that July 12, 2023 letter? Was there indication that the lender was willing to extend the loan?
Willing being the key word there, Your Honor. The letter, as described by defendant himself, merely transmitted a draft extension agreement. And it provided that if certain conditions were satisfied, the lender, in its sole discretion, might consider an extension. Those conditions were never satisfied. Not even defendant suggests that those conditions were ever satisfied. So this letter on July 12, that defendant relies upon, transmits a draft, and nothing happens. The extensions aren't met. We then sent a letter dated July 18, a week after, saying the loan matures on July 21. So there is no evidence in the record that there was in fact a loan extension, and indeed, on page 4 of defendant's reply brief, they admit, we're not arguing that the loan was extended, we're arguing that the loan may have been extended. I submit, I don't see how that helps defendant's position, and that is the very definition of speculation that does not suffice to defeat a motion for summary judgment.
What about the PDL case?
PDL, Your Honor, is simply not on point. In PDL, the court did not rule based on the notion that there were some additional obligations guaranteed by the guarantor. The opinion relies upon the fact that there were, quote, that it was unclear whether the guarantees remained in effect because there had been some underlying amendments to the loan agreement, and it was unclear whether the guarantees had in fact come due because there was an issue as to whether the lender had accepted some alternative performance. PDL does not stand for what they say it stands for, and in fact, after PDL comes I-payment and several cases following I-payment. And I think just about each and every one of the justices on this panel sat on one of those cases. We cite them in our brief. Almost every one of them go directly to the point that Justice Rodriguez made, which is that in this case, the other obligations that defendant relies upon have nothing to do and do not affect a condition precedent to the unconditional promise to repay. I-payment makes that specifically clear, and several cases following I-payment that all, by the way, post-date PDL. Okay. There's counsel makes this point that the note isn't in the record, and that's true. The note's not in the record because the note talks about calculating interest payments under certain conditions. The guarantee in this case was for the principal amount of the loan. There's no question about interest. No one has ever asked for interest. No one is asserting any claim to interest. There's no question about an interest calculation due under the note, under the guarantee, or under our request for attorney's fees, or anything having to, the note is irrelevant to what this case is about. It has nothing to do with anything, okay? And then I think one last point, if I could. Counsel just references Section 2A of the guarantee in their argument. This is not mentioned in their brief at all. This was not mentioned below. I don't know what the argument is. The claim appears to be that we didn't satisfy 2A. I don't know where this comes from. The obligation under the guarantee explicitly says in Section 3, we cite this in our brief, that when there is an event of default, the guarantor's obligations are immediately due and payable. That's the obligation of the guarantee. These are sophisticated parties. This was a substantial loan. Defendant is a sophisticated player in this space. To now come up with all these different arguments, including new ones made at argument for the first time to try to get out of his obligation should not be tolerated.
Were these expressly waived? Were the defenses expressly waived?
Well, there are express waivers of many defenses. I don't know that in fairness to counsel, I don't know that that's what we're talking about here. They're trying to suggest that there were factual disputes. But to your Honor's question, there are many defenses that are waived, standard waivers, and so that would just be another reason why, for example, none of these arguments have any weight. If there's no other questions from the panel, I'm happy to rely on our papers. Thank you.
The guarantee is of the record and is certainly a document which is important in the court's determination. I don't know that we've just raised the issue of demand for the first time. I believe the issue of the demand was raised in our papers, both in our brief in substance and our reply brief. In addition, paragraph 10 of the guarantee, which is also part of the record. Paragraph 10 very clearly says that interest rate will be determined on costs and that the costs are in excess of the $9 million. So I don't believe that the note is not a document which is extrinsic to the guarantee. In fact, the note is very important to determine that the interest calculation that the court could use on the costs, which again are permitted in excess of the $9 million, are permitted. The reason that there's no evidence of the extension is because the plaintiff or the respondent chose not to put any evidence into the record.
Thank you, counsel. Thank you both. Kato versus Forest State Commercial. Counsel, you're here for the respondent, right?
Correct.
Please.
May it please the court, Jessica Smith for the respondent. So just briefly, at least issues of fact exist as to whether This accident arose out of FedEx's use of the premises. We have a FedEx employee who was injured after he was bringing his truck back to this location, which FedEx leased for that very purpose. And this plaintiff admitted that shortly after the accident, he made a statement saying that he slipped from the ledge of the truck and not actually because of a condition on the property. He acknowledges that he made that statement, and that's in page 225 and 226 of the record, as well as...
How's that statement admissible?
Plaintiff has acknowledged this statement. He has admitted that he made the statement. There is also testimony.
Who's offering that statement here? It's not the plaintiff, right?
It's not, but it is
Isn't
also...
it hearsay?
Even if it was, it's an admission against his interest. It's also...
How is it an admission against his interest? He's not a party here.
Well, he's a party in the overall case. This is a third party action. So plaintiff is a party to the action. It is against his interest in that action where he's bringing for his personal injuries. So this is
your argument with regards to the admissibility of that statement, that it's a statement against party interest?
Yes. I'm sorry, can you just repeat the beginning of your question?
Is that your complete argument with regards to the admissibility of that statement, that that is a statement against interest?
It's also a present sense impression that was recorded. It was recorded shortly after the accident.
Present sense impressions are supposed to be contemporaneous, almost like you're giving a play-by-play of what you see. Here, there was time for reflection, and in fact, he got an important fact wrong: the date.
So there really wasn't much time for reflection, and I believe present sense impression can be contemporaneous or shortly thereafter. And
it's not supposed to be, my understanding, correct me if I'm wrong, that present sense impression is not supposed to be you giving a synopsis of what it is that you saw. It's supposed to be exactly what it says, a play-by-play of what it is that you're seeing.
Well, he wasn't. He was just saying that exactly what happened to him shortly thereafter. I mean, it was mere minutes, if anything, after that. But it also doesn't matter here because plaintiff has admitted in his testimony that this is a statement he made. So we don't even need to get to the written statement. Also, his supervisor testified to the conversation where plaintiff also orally made it. Made that description of the accident. The supervisor also confirmed that plaintiff made that written statement. And then we have the hospital records, and this is critical. Plaintiff actually admitted that he told the Montefiore employees that he slipped getting out of the truck. And I just want to mention the citation is to 306 in the record. So all of these items together, demonstrate there are at least issues of fact as to how this accident occurred and that it was in fact the plaintiff slipping out of his truck and nothing to do with the property condition. And if there's no questions, I'll rest on my brief.
Any further questions? Thank you, counsel.
Thank you for hearing me.
People versus Auke.
Good afternoon, Matthew Bova from Mr. Auke.
We better start with a waiver.
Sorry, Your Honor?
Start with the waiver, please, the appeal waiver.
So the record indicates confusion, therefore the government cannot meet its heavy burden of proving a knowing involuntary waiver of a fundamental right beyond a reasonable doubt. I'd like to go directly to page 11 of the transcript. The court says to Mr. Auke, you're also waiving your right to appeal, goes into an explanation of the appeal, and then says, Mr. Auke says, I cannot appeal, I'm waiving my right to appeal. That shows confusion.
Right, but then the court goes on to explain and maybe rehabilitate that particular part of the confusion.
No, there's insufficient evidence of rehabilitation, especially because, for two reasons. I mean, first of all, there's nothing, the fact that it's very jarring that someone who has purportedly had a discussion with his attorney about the written waiver of the right to appeal is saying this in the middle of the colloquy.
I don't know about that, counsel. I mean, I think many of us have sat here, sat in the criminal court, so I don't know if that statement is in fact true. But what I will say is that after he says, I cannot appeal, I'm going to waive my right to appeal, then the court goes on to respond that there are certain claims that survive the waiver of appeal. And then the court also goes on to question and ask, do you understand everything so far? And the defendant says yes.
He says that after that expressed confusion, but then also he then says, I don't have no other choice, which is also, and that's on page 13.
And the court said you do have a choice. And going back to what my colleague just said about going through all the claims that survived the waiver, the court asked, do you understand? Answer, yes.
The court does say that, but I think the most critical point as to the voluntariness problem, which is related but independent from just the confusion problem, is that when Mr. Coupe says, I cannot appeal, I'm waiving my right to appeal, the court says, he went over that with you. You're waiving your right to appeal. This is presented to appellant.
The court also went on to say what rights survive, right? Yes. So that could be, the court could have interpreted what the defendant said, either that he thinks that he could no longer appeal, or that he was told that there's some things that he could appeal. And whatever the confusion was, granted there might have been confusion, it was clarified by the court.
Well, the government has to prove this beyond a reasonable doubt. It's not just we think there was a clarification here. It's
the proof of that is they asked him if he had any questions, if he understood, and he said yes twice.
Well, but that also doesn't clarify.
Your position is almost like the minute that there's any confusion expressed by the defendant, that's it, it's over.
Well, no. But the problem here, though, is that when the court presents this to appellant as if this is a done deal, you're not here to articulate.
The court says you always have a choice whether to accept a plea offer, and that if he didn't want to plea, we'd end the plea proceedings and schedule the case for trial. The court says that. He gives him the option.
But that's
he doesn't say you have to absolutely plead guilty.
That's after two repeated statements that indicate that Mr. Coupe does not understand that this is his choice. So I hear that there are arguments on the other side, but this is not our burden. This is the government's burden, and this is not a great record. This court has seen far better records than this, indicating a clean waiver.
The only alternative the court had at that point, given what you're arguing, is to vacate the plea and say we're going forward.
Well, I think what the court had to do is make it very clear to him. Make it very clear. And you seem to think that this is a done deal. And my statement to you on page 11...
The court may not have used the words that you used, but we think that, well, at least I think that the court used appropriate words to basically say that.
Well, I mean, I think a good analogy, Your Honor, too, would be a guilty plea. On page 11, again, when he says, he went over that with you, you're waiving your right to appeal, and it involves those issues, as if this is not here for you to make a decision. Imagine it was a guilty plea, and Mr. Coupe said, I'm waiving my right to a jury trial? I'm waiving my right to trial? And the court says, oh, that was already covered. You're waiving your right to a trial. That would not be a voluntary plea, because it has to be expressed to him that it's a choice. At a minimum, we have confusion. On the merits, violating two court-order deadlines is inherently unreasonable.
But the judge specifically says you always have a choice. When he says, I have no choice, you always have a choice.
The court says that to him, but that's after these two very pronounced expressions of confusion. So the point ultimately is that there is confusion in this record. There's arguments on both sides, but the government has to have a very clear record of a waiver in order to bar the 3030 claim. And
let's move on to the 3030 claim.
So as to the 3030 claim, the government violated not just one, but two court-order deadlines, provided absolutely no excuse.
What were the two deadlines? Because the way that I understood it, there was a, what is it? An October, was it an,
October 21st?
I think it was. Well, there was one deadline where the decision, that was the decision, the date that the court was supposed to issue the decision.
Yes, that was December 3rd.
Presumably, the people's response was due sometime before then, right? Because the court needs that, right? On that date, the people do not submit a response, right?
Yes.
And instead ask for 2 weeks.
Yes, Your Honor.
And it's adjourned for 90 days. Is that right?
It's adjourned then to February 4th, so that's 2 months later.
Right.
They ask for 2-week extension of time. They then blow that deadline by over 45 days.
Okay, and when do they actually file their response?
They file on February 3rd.
The date that it was returned.
I think it was the day before the newly set decision date. So all this court...
Did they proffer a reason as to why they didn't have...
Not at all. I mean, that is what... I mean, even if they try, this would be a pretty extreme delay, but I think what really seals the deal here is there's not even an explanation. It's basically just an assumption that one can just violate deadlines, show up in court, and not provide any excuse at all. That happened not once, but twice. That's inherently unreasonable.
I'm not understanding. When's the second time?
Because the court sets the first deadline is the decision date on December 3rd. Then the government asks for 2 more weeks. They then blow that deadline by 45 days, filing not till February
Saying
3rd.
they didn't file within the 2 weeks is what you're saying.
Yes, yes. So they're violating two deadlines. This court's, if that, I mean, common sense shows that that's inherently unreasonable. This court's already held that in Bonilla. Court violation of court order deadlines is an unreasonable delay.
Let me ask you a question, because the court seems to rely on the fact that 54 days is a reasonable time for delay based upon cases that we might have had coming out of this court. Why is that not reasonable, or why is that not sufficient in this particular case?
Because that number is just picked out of a hat coming from a case that did not involve a violation of court order deadlines. In the abstract, you could imagine a situation where 54 days of delay is reasonable, but not when you're violating two court order deadlines. The court order deadlines provide the standard of reasonableness in 3030 and in our court system in general. As the court erred in assessing the chargeable time, the 3030 motion should have been granted. Thank you.
Thank you, counsel. You have time to rebuttal as well. I'm going to give you a little extra time, counsel, because we gave extra time to your opponent.
Hello, Your Honors. May it please the court, Kevin Peterson for the Bronx District Attorney's Office. There was an exceptionally strong appeal waiver in this case. Defendant consulted with counsel twice about the appeal waiver specifically.
What about the record where your adversary seems to talk about confusion? I can't appeal. I'm waiving my right to appeal, suggesting that there was some confusion and not necessarily clarified by the court.
Your Honor, it's our view that the defendant was actively engaged in the appeal waiver process. He wasn't just a yes man. He wasn't just saying yes, 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 yes. He had a question and he asked the court. The court, first off, had said that he always has a choice, and then the court addressed specifically his question of what is an appeal? So you're telling me I can't appeal? And the court asked him if he was satisfied by that explanation, and he said yes, repeatedly. He said he was satisfied by that explanation, which shows that he had been thinking about it. He was weighing his options, like, does he really want to do this or not? And he was trying to understand the consequences of doing it, and he decided that he did. In addition to that, he signed 2 written waivers of appeal. As we mentioned, he repeatedly manifested his understanding, and the court's colloquy closely followed the model colloquy, so all of the elements of a strong appeal waiver are present here, I submit.
Counsel, moving on to the 3030, the lower court, in reading its decision, basically states that 90 days to file an answer to the motion here is not within a reasonable time period. And then it goes on to say, nor did the people offer any explanation as to why the response was not filed timely. Nonetheless, after making that conclusion, the court goes on to exclude 54 out of the 90 days based on Johnson. Is it your position that the Johnson case creates this per se rule that 54 days is per se reasonable?
No, Your Honor.
So what are the factors in this case that make the exclusion of 54 days reasonable?
Well, we believe that Justice Lorenzo looked at the circumstances of the case, and he found that 90 days was not reasonable.
Well, no, I think the way that I read it, he relied heavily on Johnson, because his first statement is that it is not within a reasonable time period. And then he goes on to criticize that you don't even give a reason as to your delay. So in my view, what are the factors that make it reasonable? Because this is a case where this matter had been pending way more than 6 months, right? And the government was the beneficiary of the COVID toll. But even despite that, you had over 141 days, 170 some odd days chargeable to you. So under what view is it reasonable to exclude an additional 54 days?
Your Honor, the COVID-19 pandemic was underway. There were all sorts of difficulties in processing cases at that period of time. It was 2021, the height of the pandemic. And we wouldn't say that People v. Johnson set a per se rule of 54 days. This court
I'm glad, because it doesn't say that.
Exactly. In People v. Roebuck, this court found that 70 days was a reasonable period of delay for 30.
Well, and that's my point, that the reasonableness, you have to tie it in to the specific facts and circumstances of the case. And I don't see where the lower court did that here. The lower court just blanketly relied on Johnson to say 54 days excluded. So I'm giving you the opportunity to tell us what made it reasonable here to deduct 54 days on an adjournment that the people didn't even give a reason for.
Your Honor, there was a gun that had been caught. They had been indicted by the grand jury. The record does not have a whole lot of facts specifically about what he looked at, but it was in his purview to set his calendar. He created the deadline that was violated, and so it's in his wheelhouse to determine how much of that was reasonable or not.
So, but I think the question really is, are the people obligated to put a reason on the record as to why they're requesting more time to file their motion, why they didn't meet the deadline that was set?
They might be, that would certainly be the best practice. Nonetheless, the standard here is abuse of discretion, and what Justice Lorenzo did was an eminent exercise of his discretion. I apologize, of his discretion. And so we ask that Your Honors abide by that.
Thank you, counsel.
Thank you.
The government's made no attempt to distinguish Bonilla because Bonilla is directly on point. In Bonilla, this court specifically held that the time following the blown deadline with no excuse is chargeable to the prosecution. Cases like Johnson. Johnson explicitly also said that there was no actual delay. Here, there is the violation of 2 deadlines. That is inherent delay.
What about counsel's argument that this is within the judge's discretion to determine? Just like the judge set the deadline, the judge is determining what is reasonable or unreasonable based on the deadline that was set.
Well, the judge makes no determination, because the record would provide no support for the determination that the deadline was unreasonable. I think it's a totally different analysis if there's some kind of argument. Judge, you set us with a 2-week deadline. We can't comply with that. That's impossible for us to comply with.
Oh, you're
we need an
saying
extension.
That by them missing the deadlines, we can assume that it was illusory, or because that's what Bonilla stands for, right? That there was some kind of illusory or inaccurate representation. We just have missed deadlines. Are they the same thing? Because in Bonilla, weren't they really talking about statements of readiness on the record as opposed to missed deadlines in the 30-30, opposing the 30-30 motion?
No, that's another part of the decision. But in the analysis of the exclusionary time under the second to last paragraph of the decision, this court said, the people did not respond to defendant's second speedy trial motion until April 8th, 2010, although the court had ordered them to do so by March 11, 2010. Thus, the people are charged with a 28-day delay in resolving the motion. This is Bonilla times 2, because we have 2 violations of court-ordered deadlines. If the government had said we have a reason, such as there was a problem relating to...
Do you agree that if this court finds that the waiver of right to appeal was valid, that your 30-30 claim is foreclosed?
Yes. But the waiver is invalid. The 30-30 claim is meritorious. Thank you.
Thank you, counsel. Thank you both. Finally, Carlotos v. Newsmax Media. Please.
Thank you. May it please the court, Mark Balin for the appellant. And by the way, thank you, Your Honors, for allowing oral argument in this appeal. You granted this request, and it's been a long afternoon, so I appreciate this, all that you've done. I'm going to get right to the point. We requested the oral argument because we want to emphasize the importance of the timing in our situation. There's a trial in the underlying matter in Delaware that is scheduled for the end of April, so we're about 2 months away from trial. And this is an important issue, obviously, to these litigants, but also, I think, to the general public in New York, too, who perhaps use this mechanism of subpoenaing from out-of-state matters.
Can you get the issue of quashing the subpoena against Father Carlotos even before the Delaware court? You cannot, right?
No, because the respondent, he's not under the jurisdiction of that court. And there is a special master, as the Supreme Court Justice pointed out, who is dealing with discovery. But he very much said that, if the New York judge needs anything, let me know, and I can make rulings about, for instance, carving out exceptions to the protective order to give the documents.
Can I ask you a question just about the application of 3119? Does it require some kind of authorization from the Delaware court? And did you have that here?
So it's very interesting. For those of us who've been practicing a long time, the rule used to be that you would get typically a commission from the court in the jurisdiction in which you're litigating your case to go to another jurisdiction with that commission, and you would show it to a judge or to a clerk in that jurisdiction and get the subpoena issued. The Uniform Interstate Deposition and Discovery Act was adopted in New York, I think 10 or 15 years ago, and they have a provision which allows essentially an attorney, an attorney of record,
Subsection 4.
it's subsection B4, I believe
Right.
it is, to do that. And that's an exception, and it makes it sort of consistent with federal practice, where you can do that in federal practice. But most states, including New York, always required the commission route. But that's changed now. And that's the practice that was followed here. It was followed to a T. The lawyers in Delaware, the Delaware attorneys, they signed the subpoena in Delaware. They gave it to the New York attorney, also for the client. They came to, the New York attorney issued a New York subpoena and signed the New York subpoena as if they could do that in a New York action. So that was signed. The problem here, I think it's clear, at least it's clear to me, that the Supreme Court Justice did not follow CPLR 3119 in terms of addressing the matter. Instead, she said, oh, there's a judge and a special master in Delaware. I'll just send it back and let them deal with it. But that's
She also quashed it without prejudice to that. I mean, she did quash it. She just did it without prejudice, or am I misremembering?
No, I don't believe it was without prejudice. I mean, she quashed the subpoena.
Well, I mean, but the implication was go to Delaware and try to get this enforced.
Right.
Yeah.
Well, or go to Delaware, exactly, and try to deal with it there.
Yeah.
I mean, the matter of Capon, which is the Court of Appeals decision that's sort of most recently dealt with this, is very clear about the fact that a judge in this type of situation has to look at the evidence. Now, she's claimed that there weren't enough facts and things like that, but frankly, I don't think that's
Counsel,
the case.
do you still have the same trial date in April, or has that been bumped?
The trial is still scheduled for April. There is a motion for continuance. I've been informed that there is a motion for continuance on file, but it has not been ruled.
What's the current date in April again?
The current date is April 28th.
Okay. So you're asking for us to remand it to...
Well, so this is my point, which is, yes, we want, of course, a remand. However, I believe this court has the jurisdiction and has the power to order, actually, the deposition and the discovery to go forward. And I know that there are other objections. I believe those have been waived. We put this in our papers, and if they haven't been waived, we've either cured those objections or
I mean,
they're
we don't
meritless.
normally do that. We would remand it back to the trial court. Why should we not do that in this case? Like, what makes it different? Because that's not usually a normal practice to...
I understand, Your Honor, and I think that's a very good point. I think that in this case, given the timing and the fact that the court below did not properly apply the law, and then we moved for reconsideration, or the counsel before her at the time moved for reconsideration or rehearing, and she rejected that and sort of doubled down. And so I think in this circumstance, it would be useful to have this court, which I believe it has the power to do, to reverse the order on the motion to quash and order that the deposition and the discovery go forward. And if there are objections during that time, of course, we can address them, before the court then. But to go back to court and have her issue an order that allows us to go forward would not be doable in the time period that we have.
Thank you, counsel.
Thank you.
May it please the court, George Soteris and Associates for the respondent. The issue here is that we have a subpoena that is a quintessential fishing expedition that's intended to...
Let me ask you a question. Was there any argument that the information sought is utterly irrelevant here?
Yes, that's what we argued in the court below. And I think that the court didn't have the information, or at least not enough information, about the specifics of the Delaware action. That's
They had the complaint, though. The complaint, right? The complaint. They had that, right? The complaint.
Just the complaint. But when it was briefed, it was revealed that the only two bases for this subpoena are, one, a news article in the National Herald, it's a Greek newspaper, which reported that Father Alex Carlotos had counseled and supported Mr. Poulos, the CEO of Dominion, in a time when he was getting death threats as a result of what was happening with Dominion. Nothing about, and I emphasize this, Father Alex giving any legal advice or partaking in conversations about who Dominion should sue or shouldn't sue. So we start with pure speculation, fishing expedition, trying to find discoverable information, and we end up with a news article about what someone may have said or didn't say. In addition to that, in the affidavit supporting their cross motion to compel, there's a statement that what this is all about is to try to discover, and I emphasize, try to discover what Dominion, the decision that Dominion did or did not make, whether to sue Red Apple Media and John Katzimatidis. The only connection there is Father Alex, who happens to also be a priest for John Katzimatidis. So what's really happening here is an effort to try to discover information. What we don't have in the record is anything indicating that Father Alex had ever participated in any conversation involving the Newsmax litigation. So
Counsel,
it really boils down to...
You're very persuasive, but shouldn't Justice Sweeting have ruled on this, because then she could hear from both sides and make a record?
I think that she did, and I think she treated this, perhaps it wasn't an elaborate decision on the record, but she said, I don't have enough information about the litigation. And what she's really saying is, what is the connection between these theories that John Katzimatidis and Mr. Poulos had conversations with Father Alex and the actual litigation? And all they come back with is, oh, well, the idea that there was no lawsuit against Red Apple Media, and they say hundreds and thousands of other news networks that were reporting these essentially untruths about what happened with Dominion and false statements. And so what they're trying to do, and what they could easily do, is make that same argument in their litigation by pointing out the fact that Dominion didn't sue the hundreds and thousands. Why do they need to go after the priest who happens to be counsel to the CEO of Dominion? Is that not harassment? This court should, if this court's going to rule on this, and perhaps the judge got it wrong on the Interstate Deposition Discovery Act, but if this court's going to rule, it should see this subpoena for what it is. It's a fishing expedition, one that's lost at sea in a whirlwind of Dominion's, Newsmax's own lies and conspiracy theories. And they're coming back to try to harass the CEO of Dominion to try to gain leverage, litigation tactic, and that's not what a subpoena is about. They have nothing in the record that ties Father Alex to any of the events that occurred that are the subject of this litigation.
Thank you, Counsel.
Thank you.
I may address some of those points. First of all, in the record is the fact that Father Carlotos admits to having communications with the CEO of Dominion, who's the plaintiff in the underlying action. And it was around the time that of the
Counsel, I got to say, it seems very attenuated. It does seem like a fishing expedition. The question is whether we can rule on that or not. You know, I mean, first of all, what privilege might apply, you know, as a pastoral person, the Father Carlotos? You know, how is it relevant? You know, you make this argument about why didn't you sue, you know, other people besides just Newsmax and a couple other people. You know, that's an argument you can still make in the absence, I gather, of taking that deposition of Father Carlotos.
Well, again, the standard here, let's get back to what the standard is under the Court of Appeals.
It's utter irrelevance. I understand utter irrelevance, but I don't know. To me, you're skirting utter irrelevance.
Or where the futility of the process to uncover anything legitimate is inevitable or obvious. And that's not the case here. It is actually, frankly, based on some of the documents that we were not allowed to permit, not allowed to present to the judge. We asked the judge below to allow for a submission of these confidential documents, and she wouldn't accept that. She didn't entertain that. But in those documents, there are, and they're confidential, I can't get into details, but there are communications with emails and other communications reflecting the discussions between Father Carlotos and Mr. Poulos, who was the CEO.
What questions do you think you're going to be asking?
Well, going to, for instance, Mr. Katsamatidis, the owner of WABC. He also received, his company also received a demand letter from Dominion, just as Newsmax did. But right around the time that Father Carlotos was communicating with Mr. Poulos, they then decided, Dominion decided not to sue WABC. And WABC, by the way, hosts, has Rudy Giuliani as a host on that show. He actually was on the radio numerous times. He also appeared on Newsmax. And one of the issues in this case is causation of damages. You had some big players here, Fox. I know that some of the judges on this panel are actually involved in some of those matters. And then you have some smaller players. And WABC and Newsmax are these smaller players. And the theory here is that Newsmax was a small fish. And they were really, and Dominion, and based on some other communications we have from Discovery, shows that Dominion didn't think that Newsmax was even worth going. They didn't send anyone onto Newsmax to rebut these accusations because frankly, I think the implication was that they didn't think Newsmax was important enough. And so if that's the case, what is the damages that were caused by Newsmax? That's an important issue in the case, causation of these damages.
You just tie it up. So
WABC.
But how's that related to the Carlotos EBT that you're trying to get?
Right, and Carlotos, as counsel admitted, was also connected to Mr. Katsamatidis at the same time that he's having communications with Mr. Poulos. Then he might have information relating to why they decided not to pursue WABC, which frankly is probably because they're not a big fish. They didn't think that they were really injured by what was stated on those programs, and that would similarly apply to Newsmax. So it is, Father Carlotos is the connection here. He's the linchpin between the Dominion and the WABC.
Got it. No, you make that point. Thank you, counsel. Thank you both.
All right, thank you very much, Your Honor.